Hello, it's my pleasure to welcome you to this webinar on defending mortgage possession proceedings for the Housing Law Practitioners Association. My name's Sam Madge-Wyld and I'm a barrister practicing at Tamfield Chambers, and defending mortgage possessions are one of my specialisms, and I'm also the co-author of Legal Action Group's Defending Possession Proceedings, and it's been my pleasure, or not pleasure, depending on which way you look at it, to have just rewritten the chapters on mortgage possession proceedings for the next edition of the book, which hopefully I'm told shall be published by the end of the year. Now, the purpose of this webinar is to give people who represent or advise borrowers with mortgages secured against residential property an overview of the defences that can be used against lenders who want to recover possession of the borrower's home in order to recover the sum that's been advanced. I wish to stress that it is not intended to be an exhaustive and detailed analysis of all of the defences, let alone some of the defences available to a borrower, or indeed a comprehensive explanation on the law of mortgages. That would take days, if not weeks, to do, and we're limited to an hour, hour and a half. And indeed, you'd all be tearing your hair out if you had to sit through a webinar on absolutely everything. But what the aim of this webinar is to do is to make you aware of the types of defences that are available, and focusing in slightly more detail on the day-to-day offences that are most likely to be utilised at a first hearing for possession. Now, the predominant focus of the webinar then is how to prevent the immediate threat of a possession order and the loss of the home. However, it's important that anyone advising borrowers facing a claim for possession needs to be aware of the wider context in which these claims arise. Often, defeating a claim for possession may only result in a short stay of execution, and it could even sometimes be preferable for the borrower to give up possession, albeit on their own terms, i.e. by them selling the property so as to raise the sums that are owed, if the mortgage happens to no longer be affordable or is unlikely to ever be repaid. It's always worth bearing in mind that a defeated lender who leaves court without a possession order at all, and I'm not talking about a suspended order, but leaves with nothing, will in most cases have other remedies, such as obtaining an order for sale and sometimes bankrupting the borrower, which in the long run will probably result in the borrower losing their home. It's therefore important, and whilst it's not the purpose of today, that those practicing in this area need to make themselves aware of the bigger picture. Although this webinar is aimed at defending possession proceedings in court, in some cases, negotiation out of court, coupled with a threat of bad publicity by a complaint to the Financial Conduct Authority or the Financial Services Ombudsman against high street banks with an established brand, can sometimes have a better chance of resulting in the borrower retaining their home than would any defence to a possession claim. So it's always worth bearing that in mind, and having regard to the rules that regulate the conduct of high street banks and other lenders operating under the regulation of the Financial Conduct Authority. That being said, most of your clients will come to you facing the immediate threat of a possession claim, if not on the day, then maybe a few days before, and clearly resisting that claim will be the primary aim. And therefore that is obviously what this webinar will be focusing on. The structure of the webinar will therefore hopefully give you an overview of the following subjects. First of all, we'll look at very briefly the different types of mortgage that there are, the statutory regulation of mortgages, then look at the defences that are available to a borrower, and finally the remedies that might be available once a possession order has been made. But most of today will be focusing on 2 and 3. And just before we do begin and come and have a look at the slides, I want to start with a quote from Lord Macnaghten, which has been in Defending Possession Proceedings, I think, since it was first written, and a quote from my predecessor writing the section, Derek McConnell. And Lord Macnaghten in 1904 said, "No one, I am sure, by light of nature, ever understood an English mortgage of real estate." And if I may be so bold, I'd say that's as true today, if not more so, than it was then. And why is it more complicated now? Well, not only do you have to have an understanding of the English law of mortgages, but nowadays you also need to have a working knowledge of real property, trusts, consumer credit law, family law, orders for sale, and even insolvency at times. And if you are not familiar with these areas at all, then I would suggest that if this is something that you are going to come back to advising on, or you're new to, it is something you are going to have to at least have a degree of knowledge about, because it's that knowledge which is going to identify the types of defences that are available to you, and hopefully that will come apparent when we go through them in more detail in a moment. But again, I'm not going to pretend that you're going to leave this webinar understanding everything, or even most things to do with mortgages. Hopefully, however, this will give you enough information so that you will at least be able to identify the defences that might be available to a client of yours that faces a possession claim brought by a lender, and understand the defences that are most likely to result in your client keeping their home. So let's turn to the slides then. And first of all, I just want to flag some of the key resources which, if you are doing the duty desk at court, I would suggest that you should always be taking along with you. The first are the two possession books, which are an absolute essential if you're going to be doing this law and you don't have the knowledge at your fingertips, which quite frankly nobody does. There's the Housing Possession Duty Desk, which is done by the brilliant Simon Mullings and Sue James, recently released, and then there will be the forthcoming latest edition of Defending Possession Proceedings, where hopefully my aim is that most of the answers, if not all the answers, and the more detailed analysis is provided within the chapters on mortgage possession proceedings. So if you identify a defence, hopefully the new chapters in Defending Possession Proceedings will tell you the elements of each defence and when you can utilise it. In addition to those books, I would also suggest having those sections in the third line of the Consumer Credit Act to hand, and also what's colloquially referred to as the RAO, which is the Financial Services and Markets Act 2000 Regulated Activities Order 2001, Article 61 and 61A, and that should be 61A onwards, because that sets out the circumstances in which a mortgage will be a regulated mortgage contract, which, as you'll come to see in a moment, is vitally important now when identifying the type of defence available. And the 61A onwards sets out the articles or the exemptions to regulated mortgage contracts. And then the mortgage arrears pre-action protocol, because that is a very useful tool to at least securing an adjournment or a bit more time at a first hearing for possession, provided that the court has jurisdiction to suspend or adjourn under either the Consumer Credit Act or the Administration and Justice Act of Justice. Right, but starting then with the types of mortgages and their effect. Start with the first question of what is a mortgage, and historically this was could be a very complicated question, because there are various types of arrangements which were legal mortgages, but now what we're really talking about is a legal charge, often registered against an estate in land, but it is not itself an estate in land, albeit it does give the mortgagee or the lender an immediate right to possession. And that's one of the most common things that any law student will recall about a mortgage, so that as soon as the ink is dry, the mortgagee has a right to possession. But in practice these days, of course, mortgagees don't just issue claims for possession. There are various rules that they have to comply with as to when they do. But that is still the preeminent feature of a mortgage, is that whilst it doesn't create an estate in land, a mortgagee will have a right to possession, and that instantly makes it much more difficult for a borrower to resist a claim for possession, if that is the feature of every mortgage. But as we'll see, there are ways of stopping them from doing so. It's also important to remember that the mortgage's purpose is to give security to the lender for the debt that has been advanced to the borrower, and again, so that's fundamental to how a mortgage is enforced. It should only be enforced as a means of recovering the security for the debt given, and there's a principle we'll see in a moment that any enforcement by a mortgagee must be in good faith, and in good faith means it must be for the purpose of recovering security. It can't just act capriciously or arbitrarily. And there are 4 particular rights of enforcement which other creditors do not have, and they're their possession, sale, point to receiver, or foreclosure. We don't need to worry about foreclosure these days because it's largely a historic remedy. It does still exist, but it's not a popular one, and is almost unheard of now. But the appointing a receiver doesn't, for various reasons, doesn't tend to arise where you have a first charge of residential property, which will be by and large the majority of the cases you're likely to see where possession is sought from a person's home. So we're not going to consider that either today. And likewise, whilst the right to sell is probably the most important right that the mortgagee has, because once a property is sold, what's called equity of redemption is lost, which essentially means that any legal right that the borrower has in the property is extinguished. So it's vital. Once sold, that's it, it's game over. Again, most lenders nowadays recover possession first before then selling with vacant possession, and it's, whilst you need to be aware of the importance of preventing a sale, in most cases preventing the claim for possession will result in property not being sold immediately. There will always be exceptions, but again, the main focus for you will be on initially resisting possession. It's also important just to note at this stage, before we come to have a look at regulated mortgage contracts, that whilst you'll probably be aware of case law which establishes that mortgagees can recover possession without a court order, nowadays that's rare in the case of regulated mortgage contracts, because Section 126 of the Consumer Credit Act 1974 provides that a mortgagee cannot enforce a mortgage other than by order of the court. The remedies available if the mortgagee breaches Section 126 aren't great. You're essentially limited to getting an injunction, and if the property has already been sold or contracts have been exchanged, then you're not going to get an injunction. But it does mean that the majority of mortgagees will seek an order of the court before recovering possession or selling the property, and is why you just don't tend to get these days possession being recovered without a court order. You're probably all familiar with the various types of mortgages. Indeed, there are lots of other types than this, and many financial products on the market. but you do need to be aware when looking at the mortgage that your client has as to whether it is a capital and interest repayment, or it's interest only, or it's a bridging loan or an all monies charge, because it will have a bearing on the defence. For example, certain types of bridging loans are regulated mortgage contracts, whilst others aren't. So unfortunately, it is a good idea to familiarise yourself with the type of mortgage that you've got before proceeding on seeing what the defence is. Now, moving on to the statutory regulation of mortgages, and I'd suggest that this is a bit which you're probably going to have to pause, rewind, listen to me again, pause, rewind, listen to me again, and maybe you'll reach a conclusion as to what I'm talking about after 2 or 3 rewinds. But I'm afraid to say that there's no getting away from the fact that this part of the webinar is not the most interesting, and it's also incredibly complicated. It's something which, if you are going to be doing this a lot of the time, for the most part, there are, as I'll explain in a moment, a number of generalizations, which means that you don't always have to read the RAO to understand whether or not various exceptions apply. But in some instances, you are going to have to read in a probably darkened room with a wet towel around your head the RAO to see if a mortgage is in fact a regulated mortgage contract or not. And this is because the types of defences available depend on how the mortgage is regulated. And you nowadays have, generally, there are 3 main types of mortgage. And that's, you've got a regulated mortgage contract, a regulated consumer credit agreement, or an unregulated agreement, because it meets the definitions of a number of exemptions in the RAO, which mean it's not a regulated mortgage contract or regulated consumer credit agreement. Now, before going on to have a look at what regulated mortgage contract is, say it is fortunately possible to tentatively suggest that these following generalizations are likely to apply in most cases. The first is that a mortgage granted on or after the 26th of March 2016 that is secured against a dwelling is likely to be a regulated mortgage contract. Likewise, a mortgage that was granted between the 31st of October 2004 and the 20th of March 2016, which is also secured against a dwelling, is also likely to be a regulated mortgage contract, unless when it was granted, it was a second charge and an exempt agreement. And this is because the change in the law that took place on the 21st of March 2016 retrospectively made agreements that were not previously regulated mortgage contracts into regulated mortgage contracts, but only if they were previously regulated consumer credit agreements. And so that means that you have to consider the law before and after 20th of March 2016. But in the previously, it had been the case that if you had a first charge of a dwelling, then that was also, and it was granted after the 31st of October 2004, then that also was a regulated mortgage contract. But so most mortgages of dwellings that post date the 31st of October 2004 are likely to be regulated mortgage contracts, subject to a couple of exceptions, which we'll look at in a moment. In respect of mortgages granted before the 31st of October 2004, where you have a dwelling, that is unlikely to be a regulated mortgage contract. It's also unlikely to be a regulated consumer credit agreement, and that will have a bearing on the types of defences that can be run. So, regulated mortgage contracts. The definition of what is a regulated mortgage contract is generally set out in Article 61.3 of the RAO, But it's also important, and again, this will almost certainly be satisfied in most cases, that it has been granted by a person by way of business. So one-off transactions, where it be by friends or relatives, don't tend to be caught and don't tend to be regulated mortgage contracts. Set out in slides. By way of business, it generally means what you'd expect it to mean, due to making a profit over a period of time, but it can include one-off transactions if in the course of a business carried out by a business which is doing other things. So the crucial definition, which is in Article 61, and this applies to mortgages that were granted on or after 21st of March 2016, is if at the time it is entered into, so it's got to be at the time, it makes provision for a person to provide credit. Okay, that's going to apply when you have a mortgage, and again, obligation of the borrower to repay the credit secured by a mortgage, so that's going to be satisfied in all cases. Then you have at least 40% of the land to be secured is used or is intended to be used where the credit's been provided to an individual, or as or in connection with a dwelling. And the same applies where you've got credit provided to a trustee. Now you'll note a few important points there. There's no requirement that the land be used as a dwelling by a borrower, just that it is intended to be used as a dwelling. And also that it does have to either be used or intended to be used as a dwelling. If it's not going to be used as a dwelling, for example, it's going to be left empty and no one is intended to live there, then it won't satisfy the test. And you also have to have at least 40% of the land. So if you had a huge plot of land and a house on it, but when you looked at the land and the land was, say, 75% and the house with its garden was only 25%, then you wouldn't have a regulated mortgage contract. But in almost all cases that you will be dealing with, whereas possession of residential land, it's almost certainly likely to have at least 40% of the land secured, being used as a dwelling in which the mortgage is secured against. Now, as I said earlier, the complicating factor from this is that there are various types of mortgages which are not covered, and I'm not going to go through the detail now, just because it's too complicated to try and read out in a webinar. But you need to have a look at Article 61A of the RAO. And again, you can make some tentative generalizations. Tends to be first charges, although again, this doesn't always apply, but it tends to be first charges don't tend to be exempted agreements. So first charges tend to be regulated mortgage contracts. If you've got a second charge, then the types of exceptions like the business loan or certain bridging loans or buy-to-let mortgage contracts, where they are second charges, there is a chance that they will be exempted. But detailed provisions such as with the bridging loans, it depends on how many repayments there are, and in respect of the business loan, you have to have credit that's exceeding £25,000 along with other requirements. But you just need to be aware of, just think, well, is this a bridging loan? Is this a buy-to-let mortgage? And if those alarm bells are ringing, then you just need to go to Article 61A to have a look to see whether or not it is exempted from being a regulated mortgage contract. So now moving on to the pre-2016 regulated mortgage contracts. Since the 31st of October 2004, first charges of dwellings, unless they are exempt by the RAO, were regulated mortgage contracts, but this excluded second charges of which were secured against dwellings. But these types of mortgages could be regulated consumer credit agreements. Now, to make matters unhelpfully complicated, a mortgage that was a regulated consumer credit agreement when it was granted has now become a regulated mortgage contract. If it would have been a regulated mortgage contract if it had been granted after the 20th of March 2016, even if it was actually granted before 20th of March 2016 and at that time wasn't a regulated mortgage contract. And that's because the RAO has provided that essentially second charges of dwellings which otherwise satisfy the definition of a regulated mortgage contract pre-2016 should now be regulated mortgage contracts. And so this means that generally most mortgages of dwelling granted between 31st of October and 2004 and 20th of March 2016, if secured against a dwelling, are now regulated mortgage contracts, even if they weren't pre-March 2016. But the one exception, and the key exception to that, is that if it wasn't a regulated consumer credit agreement prior to March 2016 at the date of its grant, then it can't be a regulated mortgage contract. And there are two scenarios which I've set out on the slides, which are the most common reasons for mortgages not being regulated agreements and therefore not being regulated mortgage contracts. The first is where the mortgage was granted pre-April 2014 and it's a second charge and the amount of the credit loaned either exceeded 25,000, 15,000 or 5,000 pounds, depending on when the mortgage was granted. And that's because prior to April 2014 there was a credit limit which changed over time, but essentially if you had a mortgage which was securing a sum above those limits, then it couldn't be a regulated agreement. Now the law changed in April 2014 and the credit limit was abolished, but because the credit limit was abolished there was a new exception applied, which is where you had credit being advanced that exceeded £25,000 and the loan was for the purpose of a business, then it was an exempt or unregulated agreement. And there were a fair number of those types of loans, and indeed, as case law has shown, there are a fair number of those loans in which the borrower has allegedly asserted to the lender that they weren't living in the property as their home, and the loan wasn't for the purpose of a business, who have turned round and said, actually, I am living in the home, and therefore it's a regulated agreement. And the borrower and the lender, sorry, said no, it's an unregulated agreement. There's been quite a lot of litigation about that, but those are the two common reasons for a mortgage not being a regulated agreement and therefore now not being a regulated mortgage contract. If you have a mortgage that isn't a regulated mortgage contract, it will either be a regulated agreement or an exempt agreement, and there's no real distinction between a regulated mortgage contract and a regulated agreement. The Part 9 of the Consumer Credit Act, which gives the court various powers, for example, to suspend possession orders or change the terms of the mortgage, applies to both regulated mortgage contracts and regulated agreements. But probably the most important distinction is that the really extensive unfair credit relationship powers do not apply to regulated mortgage contracts, and therefore, while on the one hand the change in the law in March 2016, which looked to bring a whole range of new mortgages into the control of the Consumer Credit Act, or the overview of the Consumer Credit Act, one of the most powerful remedies a judge has in respect of unfair credit relationships has been excluded. So in a way, you're now in a better position if you have a regulated agreement rather than a regulated mortgage contract, because you have the full gamut of Part 9, whereas with a regulated mortgage contract, you're limited to time orders and the possessions being suspended, possession orders being suspended. We'll come on to that in a moment. And it's also worth noting on the final bullet on this slide that unfair credit relationship powers actually also apply to exempt agreements, whereas other parts of the consumer credit don't apply. But the circumstances, I say, in which you're likely to have an exempt agreement are not likely to be that common nowadays, where you have residential land, but still worth keeping an eye out for them. So why is it important to identify if you have a regulated mortgage contract? And I've alluded to some of these so far in talk, but there are two quite important potential defences. The first, which is not that common, but does arise, and I've certainly advised on a few of these, is that if you have a mortgage that is a regulated mortgage contract and it has been granted by a person, whether a company or an individual, that is not regulated by the FCA, then it is unenforceable unless the court exercises a discretion to say that it is. And that's under FSMA, which is the Financial Services and Markets Act 2000. And that is a potentially brilliant defence to claim for possession, because clearly if the mortgage is not enforceable, then the mortgagee does not have a right of possession, and that's a complete defence to the claim. It's worth bearing in mind, however, that that seems like that's absolutely amazing, but if it's unenforceable and the borrower elects not to perform the agreement, i.e. decides not to pay back any of the sum advanced or the interest and the cost, then FSMA provides that the borrower must still repay the sums advanced. So it's sort of what you call counter restitution, and often the only way that the borrower is going to be able to find the sum advance is to sell the property, and that's not necessarily going to help too much. But it's always worth having this in mind, because there are, and again, it's not really been decided yet, because there's not been a case on this where it's been crucial, but it's likely that if the lender faced with a situation where they can't enforce the mortgage, if they want the borrower to repay the loan, they're going to have to bring a claim, and there's a reasonable argument that any such claim would be a claim for a sum of money payable under an enactment, and that such a claim has a limitation period of 6 years. And so if 6 years have passed since the borrower decided that they weren't going to perform the loan by repaying it, and that the mortgage has become enforceable, and you could argue that the lender is out of time to bring a claim for the sums being repaid. So whilst it's unlikely to be that common, it's worth bearing this in mind, because you might be able to establish that the mortgage is entirely unenforceable and the time for the lender to recover the sums from the borrower has passed and their time bar. The other relevance of a mortgage being a regulated mortgage contract is, as what I've alluded to previously, is that Part 9 of the Consumer Credit Act applies, and we'll look at that in more detail in a moment. So let's move then on to the defences that may be available, and as I've said, this is not going to be a comprehensive analysis of all of these defences, because there are a whole multitude of defences, and they're all depend on the particular circumstances as to whether they apply, and we just do not have time to go through them all, but I do think it's important to have somewhere sort of in your back of your mind, or I'd say written down, and I certainly in the new Defending Possession Proceedings but tried to make sure that you do have a list of all of the types of defences that you can run, just so that even if none of them apply, you've at least addressed your mind to whether they might apply, because there are so many. But the types of defences can largely be categorised into the 5 bullets on this slide, and the best type of defence is the first one, namely the lender does not have a right to possession, and what we've just been talking about now, whether a mortgage is enforceable or not, for example, would be the first type of defence. Mortgage not enforceable, therefore lender has no right to possession. But there may be other types of defences, which we'll look at in a moment, where the mortgage might be set aside, for example. The second category of defence is where there is a third party, so not the borrower, occupier, who has a better right to possession than the mortgagee. And that might be a tenant, it might be a spouse or civil partner, or some other occupier with an equitable interest in the land. The third type of defence, which is by far and away, say, the most common type of defence to any possession claim that you're likely to see, is that, okay, a possession order should be made, but it should be it should be postponed or suspended, or maybe even the claim should be adjourned in the instant, for various reasons, which we'll come on to look at. Fourth type of defence is you might be able to have it struck out. Unlikely, but you never know if it's procedurally defective, or you may be able to, you wouldn't be able to have it struck out for non-compliance with the mortgage arrears pre-action protocol, but you could probably have it adjourned or stayed or suspended. And then the final category is where, again, it's more of a link to the third bullet point, I suppose could also result in the right to possession not arising at all, is where the arrears are reduced or extinguished by a counterclaim or a defence to a claim that, for example, increased rates of interest or costs means that there are no arrears, or they're reduced to a point that enables the court to postpone or suspend an order for possession. Have a look at the first category of defence, and that's the no right to possession. And I'm not going to go through all of these, and we've already considered briefly that the first two, possession's not sought in good faith, that is an absolute defence, and we've also looked at the FISMA point. You may very rarely be able to argue that under the mortgage agreement there isn't a right to possession. It's likely to be rare, but there may be circumstances where the mortgage deed requires, say, the sum to be demanded or the sums outstanding to be called in. Nowadays that's very unlikely. The fourth is the classic defence to a mortgage claim, which is that the mortgage is about to be or has been redeemed, i.e. it's been repaid, because once the mortgage has been repaid, that's effectively satisfying the equity of redemption, and the borrower then has the right to have the mortgage discharged. But most of the time, if the borrower has the money to pay the mortgage, there doesn't tend to be an issue, but that is a potential defence. Where you are arguing that the mortgage should be set aside for undue influence, that is a very good defence to utilise, and I will be considering that in a bit more detail subsequently. And sort of linked to undue influence or species, they're not undue influence, but they're like undue influence. You can also have a mortgage set aside for unconscionable bargain, or fraud or misrepresentation. We won't be considering those in more detail. Likewise, you have, if, say, the mortgage has been forged or been non-eos factum, it's not my deed, again, nowadays it's almost impossible to run non-est factum, and you'll need particularly strong facts to allege a forgery. If the mortgagee, the mortgagor lacked capacity to enter into the agreement, we'll be looking at that in a bit more detail later. If the mortgage broker was paid a secret commission, then that is a basis for setting aside the mortgage. We won't be, it's quite complicated, and we won't be looking at that in more detail, but there has been a recent Court of Appeal case called Wood, where that was considered in more detail. Again, for our purposes, it's unlikely to be of much assistance, which is why I'm not considering it in this webinar, because you have to give counter restitution. And most of the time, unless you're going to sell the property, most of our clients won't be in a position to give counter restitution, which is for the whole sum that's been advanced. But it can be useful for reducing costs and interest, because if the mortgage is set aside, then the additional rights to interest and costs are not going to apply. Limitation Act, again, it is possible, but almost unheard of. You may have a mortgagee that is stopped from bringing the claim for possession, and that's going to be very much on the case's own facts. It's likely to be where a mortgagee has promised to forbear on bringing a claim for possession, but it's worth knowing, but they're so fact specific and also pretty unlikely to arise. And then finally, the claim for possession amounts to unlawful discrimination under the Equality Act, which we will look at in slightly more detail, albeit again that is likely to be a rare defence that succeeds in knocking out the claim for possession entirely. I haven't included human rights on this slide for the reason that I cannot see how a human rights argument would now even be runnable. The case of McDonald and McDonald, which was decided under whether a defence, as I'm sure you all know, whether a defence to a Section 21 possession claim could be run with a Human Rights Act defence. And the Supreme Court said no, and the reason why the Supreme Court said no is because you couldn't use Human Rights Act defences to essentially disputes between two people arising under a contract, even if statute had intervened to regulate the contract. So, as you know, with a Section 21 claim, you have a tenancy, and whilst statute has intervened to set the parameters in which possession can be recovered, essentially it's a contract between two private individuals, and the same is equally true for mortgage possession proceedings. There's a contract between two individuals, and even though statute has intervened to regulate when possession can be recovered, you're going to be limited to running a gateway A challenge, i.e. you have to challenge the statute, the compatibility of the statute that is regulating the contractual relationship, and that's just not going to be a starter with mortgage possession proceedings, because there's old case law which says that Section 36 is compatible with the Human Rights Act, and the Consumer Credit Act 1974 gives the court more powers to intervene. So it's very unlikely that a challenge to the Consumer Credit Act as being incompatible with the Human Rights Act would succeed. Now, looking to the second category of defence, this is where you have the third party with a better right to possession, and it tends to be, well, I've split it into three types of occupier. You've got a tenant, be they authorised or unauthorised in possession, or an occupier with the benefit of home rights under the Family Law Act, or an occupier with the benefit of an equitable interest that binds a mortgagee. And we'll look at 3 and 4 in more detail later on. Just before we move on, though, do just briefly address the issue of tenants, because it's probably quite common for tenants of borrowers to turn up to on a duty desk where they've been serving proceedings by the lender, and they want to try and defend the claim. Generally speaking, most tenants will be unauthorised tenants, because even if you've got a buy-to-let mortgage which expressly authorises tenancies to be granted, strictly speaking, they don't bind mortgagees unless you have a very unusual mortgage deed, and therefore the mortgagee will have a right of possession against the tenant. It's only likely for you to have a decent defence if you are a tenant of a borrower who has subsequently remortgaged. So, for example, the borrower grants a tenancy to a tenant of the property and then takes out, say, a second charge against the property. The holder of the second charge, the mortgagee of the second charge, will not have a right of possession against the tenant that was already in situ. Even where you do have unauthorised tenants, the court does have power to postpone the date for possession for a period of not exceeding 2 months. And when it comes to the warrant coming to be executed, again, provided the court hasn't previously postponed the possession order, then the court has the power to suspend a warrant for possession, and that's under the Mortgage Repossessions Protection of Tenants Act 2010. And so whilst I didn't say this was a key resource, it's probably also a useful act to have to hand, even if you do have the Defending Possession Proceedings with you on the day. It's checking, because mortgagees are also required to have given notice of the claim, of enforcing the warrant of possession under the Act, and sometimes they don't do that. So it's a useful act to have with you on the day. Then, as I said earlier, the most common types of defences, which aren't really defences, but essentially the court's power to postpone or suspend possession, which I'm going to look at in more detail in a moment. You may have other procedural defences, which are set out on this slide, which I'm not going to go through in any great detail, but they're set out at length in Defending Possession Proceedings. And then finally, as I say, there may be a counterclaim or a defence to increase interest or cost provisions, which might result in the arrears being reduced so as to either extinguish them entirely, unlikely, or at least reduce them to an extent which means it's easier to convince the court to suspend or postpone a date for possession. Right, so we're now going to move on to look at some of the defences in more detail, and the first that we're going to look at are time orders, and I've expressed this section's time orders or section 36 because this is one of the key changes that have been made by bringing most mortgages into the let me rephrase that, giving the courts power under Part 9 in respect of most mortgages of dwellings and residential property, because the powers under the Consumer Credit Act are more extensive than those that the court has under Section 36. But the courts have been used to dealing with Section 36 since the 70s, and the court really needs to be reminded of the new powers that they have, which they may not be aware of. So, as I've already said, Part 9 of the Consumer Credit Act applies to regulated mortgage contracts and regulated agreements, albeit the unfair credit relationship provisions do not apply to regulated mortgage contracts. What are the powers under Part 9? Well, under section 129, the power to make a time order. There is a freestanding power to suspend an order for possession, albeit they're most likely to be combined with making a time order. There's a provision as to unfair relationships, which I'm not going to look at because, as I say, it doesn't apply to regulated mortgage contracts. But one of the best powers that the court has is under section 134, which is when it's making a time order, it also has the power to amend any agreement or security, and that may involve changing the rate of interest, changing the number of payments, and so that's a very powerful tool at the court's disposal, which goes without saying such powers do not exist under section 36 of the Administration of Justice Act. So when the court makes a time order, it may provide for one or both of the following things: the payment by the borrower of any sum owed under the mortgage by such instalments payable at such time as the court, having regard to the means of the borrower, considers reasonable. It also has the power, when making order, for the remedying by the borrower of a regulated agreement or regulated mortgage contract other than non-payment of money within such period as the court may specify. And the sum owed helpfully means the total indebtedness, not just the arrears that are owed. So this gives the court a particularly wide power because it essentially has the power to change the instalments and when the payments are to be made and the amounts of the payments, having regard to the means of the borrower. So potentially a very wide power indeed. Now, you won't be surprised that there is some fetter on this discretion, and section 129 makes it clear that a making of a time order can only be made if it appears to the court just to do so. And again, you won't be surprised that the Court of Appeal and House of Lords has considered what just to do so means in particular circumstances and how the court should exercise its discretion. And it's been held that while section 129 expressly directs the court to the borrower's circumstances, the court also has to consider the lender's position. Surprise, surprise. And so a time order, it's been held in the Southern and District Finance and Barnes case, should normally only be made on account of the borrower's temporary financial difficulty. So if you have a borrower who is in a very poor financial state and has always struggled to pay the mortgage and can provide little evidence to the court that they're ever likely to repay the total amount loaned, then the court is not going to make a time order based on the borrower's circumstances, such as paying £50 a month, say, when the monthly instalments are £1,000 a month. Even if that's what the borrower can afford, the court's just not going to make a time order in those circumstances. And the House of Lords has also held that the second to last bullet point on this slide, that time orders extending over long periods of time are usually better avoided, but in an appropriate case, it has been held that it is possible for monthly instalments to be reduced and the term extended, provided it's just to do so. So whilst generally speaking, if you have a borrower that is in a perilous state, you're not going to be in any better position as you were under section 36. There are exceptions, and the crucial point here is that there is no jurisdictional requirement that the arrears be cleared within a reasonable period, as was the case, or is the case more accurately, under section 36. And I've set out on this slide what it is possible for a court to do when making a time order. So first of all, court could extend the term and spread out the monthly payments, and I would submit that even could do that even once the term was ended, provided that there was good evidence that this would mean that the borrower would be able to repay the sum, and if, especially if you're faced by a claim by a high street bank, which quite frankly is not going to be overly prejudiced by the term being extended, provided they're going to get their money and they get their interest. But it will depend on the circumstances, and you're going to have pretty good evidence to show that the borrower can pay the reduced payments over an extended period of time. But the best example might be where a mortgage has been taken out, probably would have to be by someone who's relatively young, and at the time that they took the mortgage out, they were earning a certain amount of money, and they since got a different job which pays them slightly less, which means that whilst they're good for the money in the long run, they just can't afford the current monthly instalments. They need to pay less. The other option is the deferring of capital, so effectively turning the mortgage into an interest-only mortgage for a short period of time, and that might be, again, because there's a short period of time in which the borrower is simply unable to make the monthly instalments, but in the long run they will be able to. The other power is to amend the rate of interest, and this is the thing which always attracted quite a lot of interest or attention. But the courts are quite reluctant to do this, except for in very particular circumstances, and it tends to be where you already have a high rate of interest, which is because the high rate of interest is to factor in a degree of risk, maybe to do with the borrower or the type of loan that has been taken out. And the argument is that if you've already got a high rate of interest to factor in a risk, if the term is being extended and the sum is still going to be paid, there's no reason why the borrower should end up paying more interest if the lender is actually going to get the money that they advance, because the risk is not there. But you'll see why such powers are not likely to be utilised often, because you'll have to show that there isn't the risk of the lender losing the money, and also with the more mainstream banks that are lending at very low rates of interest these days, if you've extended the date of the time for repaying the capital, it's it's hardly really, the court's not going to think it just to reduce the rate of interest, and they're going to find it's very unjust to reduce the rate of interest if the borrower is having to pay back the capital sum over a greater or a longer period. The court may also adjourn or suspend the enforcement of a possession order on terms that essentially comply with the time order, so the mortgagee can't come back to court so long as the time order is complied with. Now, Section 36 still applies. It also applies to unregulated agreements. So if the mortgage is not a regulated mortgage contract, or it's not a regulated agreement, then you can still resort back to Section 36. But as I've said, I think if you have a regulated mortgage contract, there really is no reason to go to Section 36, because it doesn't do anything that time orders can't do. There is a general power to suspend anyway under the Consumer Credit Act, which normally will be coupled with a time order, but there may be circumstances in which the court does decide to adjourn or suspend execution of a possession order, even if not making a time order. And you just don't have to get over the jurisdictional threshold in Section 36 of the arrears having to be repaid within a reasonable period. So provided you have a regulated mortgage contract or a regulated agreement, you really shouldn't having to be resorting to Section 36 again. Just briefly want to focus on the pre-action protocol before moving on. That the pre-action protocol does not alter the parties' rights and obligations. So you may say, well, what use is it at all? Because if the lender doesn't comply with the mortgage pre-action protocol and comes to court and asks for a possession order and is entitled to a possession order, the failure to comply with the protocol won't stop the court from making an order. But that's not right, because if the court does have jurisdiction under the Consumer Credit Act 1974 or the Administration of Justice Act, if they apply, not to make a possession order. And the editorial notes in the White Book make it clear that one of the, or three of the consequences arising from non-compliance with the protocol, provided that the court has the jurisdiction to adjourn or suspend under the Consumer Credit Act, are that the claim should be adjourned. And I think the use of the protocol where it hasn't been complied with is quite a useful tool in buying a bit more time, so that you can make sure that you consider in detail a proper defence. And so definitely something to be considered, even if on its face it seems like the pre-action protocol lacks teeth. So third-party interests that bind a mortgagee. So I think we've already considered earlier, the circumstances to look out for are those on this slide. You're looking for the tenancies that generally predate the mortgage. But beyond tenancies, the most likely types of situations are where you may have a trust, whether it's express or constructive, whereby a third party has a beneficial interest in the property. They may have a proprietary estoppel, which gives them a right to a proprietary right in the property, and their interests that bind the mortgagee. So they essentially have a better right to possession than the mortgagee, and we'll look at those in a bit more detail later. There is also where you have a spouse or civil partner with home rights under the Family Law Act 1996, which also bind the mortgagee. Now, where you have a trust interest, so you have a beneficial interest under a trust, it's almost certain that won't be protected on the land register, because trust interest cannot be protected by a notice. It's one of the key features of the Land Registration Act. But you do have what you're probably familiar with are overriding interests in respect of registered land, which still bind the mortgagee even if they aren't noted on the register. Now, a tenancy of less than 7 years does not need to be registered, so provided it was granted before the mortgage was granted by the lender, then that tenancy will bind the mortgagee. But the other type of interest that's most likely to be of assistance is where the third party has an interest in land and that person is in actual occupation of the land. So you may have, say, a partner, cohabiting partner, who has paid towards the acquisition of the property, and for whatever reason they aren't the legal owner of the property. In those circumstances, they're likely to have an extra interest by way of a constructive trust. And I haven't mentioned it in the notes, but the relevant cases to have a look at in those circumstances are Stack and Dowden and Jones and Kernot. So they, if you're going to be doing this area in detail and seek to specialise in this area, I strongly recommend reading Stack and Dowden and Kernot and Jones. But say you think you've got a beneficial interest under a constructive trust, that's not enough. First of all, you have to be in actual occupation, which if you're living in the property, well, that's pretty easy to establish. But it will only apply if and it's slightly, I always find this difficult because the Land Registration Act, the way it's drafted, the way it's phrased is like in the reverse. So it's in the, you have an interest in land that's held by a person in actual occupation unless their interest is undisclosed following an inquiry by the mortgagee. So if the interest is disclosed, then they're in actual occupation. But if the interest is disclosed, it's very unlikely that the mortgagee will have granted the mortgage without at least having the occupier fill in a form postponing their interest so that the mortgage takes priority. So very unlikely that if that bullet is going to apply if there was actually an inquiry made. And then it would also, there'll be an overriding interest unless it would not have been obvious on a reasonably careful inspection of the land at the time of the mortgage and the mortgagee lacks knowledge of the interest. So if the mortgagee had attended the property and the fact that the person with this interest was living in actual occupation, if that would have been obvious, then that person has an overriding interest. If their occupation is not obvious, then the mortgagee is able to escape the overriding interest. So that is the situation in which most of these arise, is that if someone's living there and the mortgagee hasn't carried out the proper due diligence, then they're likely to be bound by the overriding interest. Final point to note is that the interest, it must be an interest in land, so a proprietary right. A license to occupy, for example, is not a proprietary right. So you do generally need a trust interest or an interest under a proprietary estoppel. Freebies don't have time to go through what is a proprietary estoppel or the types of circumstances in which an extra interest under a constructive trust arises. But those are the most common situations in which you can use the overriding interest provisions. The next situation is where a spouse or civil partner has home rights, and that will arise, they'll have home rights if their spouse or civil partner has the right to occupy a dwelling by virtue of a beneficial estate or interest or contract or any enactment, and they do not. So in short, you've got one person in the relationship. Historically, and I'm trying not to do this, but historically it would have been the husband, the legal owner, but it obviously doesn't have to be. But you have one person who's the legal owner, and then the spouse or civil partner doesn't have aren't the joint legal owner, and they don't have their own interest. They will have home rights, and those rights are capable of binding mortgagees if they are registered by notice. But they cannot be overriding interest. And what this means is that whilst every spouse or civil partner will have home rights if they don't have any other proprietary right to stay in the home, unless they've been protected by notice, then the mortgagee can take 3 of them. And so what you essentially need to have is a spouse or civil partner that is very distrusting of their other half, because they've decided, they're concerned that they're going to mortgage the property without their knowledge, so as to put their rights to occupy the family home at risk. So it's not that common for home rights to be registered, and often they're registered after the event, because it's the very fact that they've learned that the property has been mortgaged which causes them to have some concern. But by then it's too late. But it is a potential and to bind mortgagees. Right, moving on to the next category of useful defence to be aware of, which is reducing the amount payable under the mortgage. And as I've said earlier, there is the power to reduce the interest rate when making a time order. And then if you don't have a regulated mortgage contract, then the court also has a wider power to even rewrite the mortgage under the unfair relationship provisions, but as that's unlikely to apply, I'm not going to consider that in more detail. The two more, well, not common, but probably better chances of knocking out unfair interest or cost provisions are to argue either that they amount to a penalty at common law, or they're unenforceable because it's an unfair contract term. But what I'm talking about here are what I'd refer to as secondary rates of interest that apply on default, or cost provisions that apply on default, which in respect of the first, with interest, if it amounts to penalty, is out of all proportion to the lender's legitimate interest. And where you draw the line as to out of all proportion is often, it depends the judge that you get, but it's generally recognised that increasing an interest rate on default by a percentage point or 2 percentage points is unlikely to be a penalty at common law. But you may have a mortgage which increases the interest rate on default to considerably higher than what the general market is paying for interest, and in those circumstances you might be able to argue that that interest rate is a penalty. The other way of arguing it is under the if it's an unfair contract term, either under the Unfair Contract Term Regulations 1999 or the Consumer Rights Act 2015, depending on when the mortgage was granted, albeit for our purposes here it doesn't really matter whether it's under the regs 99 regs or the 2015 Act. Again, it's only in respect of secondary rates of interest, and you can't attack what are called core terms, and a core term under a mortgage is that you have to repay the sum that's been loaned within a particular time, over the term of the mortgage, and it would also be the interest rate that's payable. The interest rate that's payable is a core term, but like with penalties, you may have secondary rates of interest which arise on default, which you could potentially attack as being unfair. Now, whether a term is unfair is if it is contrary to the requirements of good faith and it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. Now, in mortgage agreements, it's like pretty much all terms are going to create a significant imbalance in the parties' rights and obligations, which are to the detriment of the consumer, especially terms which require, say, costs to be paid or an increased rate of interest. The case that's set out above in respect of penalties, the Mac-DC case, also considers the position for unfair contract terms, because there were a variety of cases that went to the Supreme Court and they considered both legal points. And it's whilst it's not impossible, it is hard to show that such a term is not in good faith, because what the Supreme Court notes is that a term is likely to be in good faith if it is common and used regularly in similar contracts. There's a reason for the term, and despite the shift in the contractual balance in favour of the supplier, the consumer is not left without protection. Now, in more regulated mortgage contracts, provided that the increased rate of interest is largely what the market does, and there will be a reason for the term, it's to prevent or to discourage mortgagors from defaulting on their mortgage. And there will also be protection, because the court retains the right, as I've said previously, to reduce the rate of interest. So under the section 129, when a time order is being made, so the consumer is not left without protection. So this means that you are unfortunately going to have to be looking at, for either arguing it's a penalty or an unfair contract term, quite considerably high rates of interest that apply on default, or very high costs, which are sort of out of all proportion to being a proper detriment, but those sorts of terms do exist, certainly not being applied by the sort of mainstream brands, the high street banks, but there are mortgages that certainly I'm unhesitatingly argue do not satisfy the requirement of good faith and can be a penalty, but you just need to find them. But it's certainly worth having this in mind. It's also, even if you're it's not such a clear-cut case, it's a good way of buying time by pleading such a defence, and it's a useful negotiating tactic, because obviously certain lenders don't want to have district judges finding that their terms are unfair or are penalties. Moving on to counterclaims, the first one to consider if you have a disabled mortgagor, probably the Equality Act. The case on the slides there, Green and Southern Pacific Mortgages Limited, establishes that the Equality Act applies to the provision of mortgages, and indeed that there is a duty to make reasonable adjustments. But what Green decided is that the duty to make reasonable adjustments does not extend to a requirement to convert a repayment mortgage into an interest-only mortgage, and that's because Ms. Green was able to afford pay the interest, but couldn't pay the capital payments, and she tried to argue that a reasonable adjustment was therefore to convert the mortgage into an interest-only mortgage. But the Court of Appeal said the duty to make reasonable adjustments does not go that far. Therefore, it's hard to see what reasonable adjustments could be made generally beyond perhaps extending the life of the term to a very limited extent. But in practice, in my view, the Equality Act can be of some assistance if it can be shown that it was disproportionate for a claim for possession to be issued against a disabled mortgagor, where you'd otherwise have a Section 15 defence, so the inability to pay is due to the mortgagor's disability. And if you can show that it's temporary and there's sufficient equity in the property so that the security isn't threatened, it's certainly arguable that it would be disproportionate to issue a claim for possession in those circumstances, especially if the mortgagee hasn't bothered to comply with the pre-action protocol or has only paid lip service to it. You may be able to run a Equality Act counterclaim, which, whilst on the Vento scale of damages, you're not likely to be getting, tens and tens of thousands of pounds. You'd probably be looking at something between low thousands of pounds up to £15,000, depending on how bad the mortgagee's conduct was. You never know, that might be sufficient to wipe out the arrears, and would be a really useful addition to arguing that a time order should be made, or maybe that the claim should be adjourned generally. The other counterclaims I just mentioned, first, you're just not going to see that anymore, but I thought, given we were looking at counterclaims, I'll just flag it. But where you may have slightly more joy is where the Financial Conduct Authority's mortgage conduct of business rules, where the mortgagee has breached those rules, they're commonly referred to as MCOB. Then if a loss has been sustained as a result of a breach of those rules, then the FSMA 2000 gives the borrower a claim against the lender. Now, often there is a chapter which is devoted to possession claims, and it largely mirrors what pre-action protocol says. It's a bit more, slightly more extensive, but essentially, unsurprisingly, lenders are expected to act fairly towards the borrowers, and possession is last resort, etc. But the difficulty is, I say, I can't quite see how, if they breach that provision of MCOB, what loss the borrower is going to suffer, other than perhaps incurring limited legal costs potentially, although I'm not sure that would work in defending such a claim. But probably where you're most likely to have more joy is if the borrower has been missold a mortgage or has otherwise been subjected to unfair practices. So they've essentially been lumbered with a mortgage that they should never have because they could just never afford it, and as a result they're having to pay increased interest, legal costs, which they should never have had to pay, and that would definitely be a potential counterclaim. Although again, establishing that, it's easier said than done. It's important just to stress that the breach of MCOB is just a counterclaim. It doesn't render the mortgage unenforceable. And there's a case called Thacker which establishes that, where a borrower tried to establish that it was a defence to a possession claim. It's not a defence, but it can act as a counterclaim, which, when coupled with the court's powers under the Consumer Credit Act or Section 36, could result in the arrears being reduced or extinguished, and therefore giving the court the jurisdictional basis to suspend a claim, an order for possession, or adjourn a claim for possession. Now, before moving on away from defences, these are the last type of defences I think it's important just to consider in a bit more detail, and that's defences for vulnerable borrowers, although not necessarily have to be vulnerable, but it tends to be the sorts of defences that are more likely to arise. And the first that I want to consider is undue influence. And again, it's perhaps I'm shoehorning this into defences for vulnerable borrowers, because you don't necessarily have to be vulnerable to be the victim of undue influence, although it's probably more likely. But this is one of the best defences for mortgage possession proceedings, and therefore I thought it merited a little more analysis than some of the others, because if this defence is successful, this results in the mortgage being set aside, and unlike a lot of the equitable remedies which result in mortgages being set aside, there is no need for counter restitution. So it essentially means that the mortgage is gone and there's no requirement to repay the capital sum. And moreover, it can also result in the mortgage being set aside even if it isn't the lender who took advantage of the borrower. It can be a third party. And there are two types of undue influence. You have actual and presumed, and when they're not really that different, you have to establish undue influence, and undue influence tends to mean the same thing, but as we'll see, a presumed undue influence is quite useful because you don't have to actually prove that one person has taken unfair advantage of another. You just simply have to point to a particular type of relationship and a transaction that calls for an explanation, and unless the presumption can be rebutted, then you have undue influence. But let's just have a look first at what actual undue influence is. The first is where you have threats or improper pressure, and that's, I mean, in a way that's like duress rather than undue influence, but the cases do say that it's the first type of actual undue influence. But the more likely scenario is where you have a relationship which exists where one person has a dominating influence over the other, and they take unfair advantage by causing the other to take out a mortgage. So you have to prove two things. One is you've got this type of relationship where one has a dominating influence over the other, and then you have to prove that they have taken unfair advantage by causing the other to take out a mortgage, and that can be difficult without evidential and documentary proof, which doesn't tend to exist when one person has a dominating influence over the other. It tends to be done in person. So the presumed undue influence is really useful, and it's far easier to prove. There you have to prove that one party has a measure of influence over the other, and there, as I said, there's a transaction that calls for an explanation. And there are certain types of relationships which are established that it's taken there is a presumption that one party will have a measure of influence, and they are what are set out on the second to last bullet point. You have a parent and child relationship, guardian and ward, solicitor and client, doctor and patient, religious or spiritual advisor and follower, and trustee and beneficiary. So that will always satisfy the first part of that test. For other relationships, you need to prove that such a relationship exists, i.e. one party has a measure of influence over the other. Now, to show that one party has a measure of influence over another, simply pointing to a family relationship is not good enough. You have to show that the borrower placed trust and confidence in the other party in relation to the management of their financial affairs. So the fact you have a husband and wife or two civil partners, that's not enough to establish the relationship. You have to show that one of them essentially is responsible for the family's financial affairs, and that may apply in some instances and it won't in others. The next requirement is you have to show that there's a transaction, in this case it will be a mortgage, that calls for an explanation. And what the case law, this is Ettridge shown on this slide, which is essentially the law for undue influence. You only really need to read one case to get an idea of how it all works. What Ettridge says is a mortgage will call for an explanation if it cannot readily be accounted for by ordinary motives of ordinary persons in that relationship. And quite crucially, the court was at pains to stress that the decision of a spouse, or I didn't say this, but we'd say civil partner now, to stand as security for their other half's debts would not, without something more, call for an explanation. So the fact that someone is willing to stand as security for their partner, it's not, you know, that happens all the time. So you're going to have to show that there was something more in it that was to why this really can't be accounted for. Have to be a particularly unfair mortgage, or there's just no benefit at all for the spouse. And the common example is where there's a failing business in which there really is no point of standing as security, because the business is almost certainly going to fail. Even once the presumption is established, it can nonetheless still be rebutted. So even if you have proved that there is a relationship of influence, and you've proved that there is a transaction that calls for an explanation, if the bank, as it will be, can prove that the decision to take a mortgage was free from the influence of the third party, then the presumption will be rebutted. But that requires full, free and informed thought. And often what the defendants or to a claim for undue influence will say is, oh, well, the party that took out the mortgage had legal advice, so it must have been with full and free and informed thought. But in a way, taking legal advice and still going ahead with a transaction which calls for an explanation actually shows the measure of the influence that they're under, and how that they can't have taken it with full and free and informed thought. Because if they had legal advice which said this is a terrible idea, don't do it, and they still go ahead and do it, if anything, it proves that how powerful the relationship is. So what banks have to do to protect themselves is follow the procedure in Ettridge, because simply being able to point that one of the borrower has taken legal advice is not going to necessarily cut it. What a lender has to do in order to protect their position, therefore, is to follow the procedure set out in Ettridge, because if there is undue influence and the lender has notice of that undue influence and does not take steps to protect its position, then the mortgage can end up being discharged. Now, a lender is deemed to have notice of undue influence, and it's notice of that there might be undue influence. They don't actually have to have notice that there actually is undue influence. They just have to have notice of the potential for undue influence. And what Ettridge establishes is that the 4 circumstances set out on this slide will put a lender on notice that there might be undue influence. And if these circumstances apply and the lender does not protect its position and there actually is then undue influence proven, then the mortgage will be set aside. So the 4 scenarios are where a spousal partner stands as surety for their other half's debts. The loan is made in the spousal partner's joint name, but the mortgagee, so the bank, is aware that the loan is in reality being made for the benefit of only one of them. Where the loan is made to a company owned jointly by both the spousal partner, and where a bank is aware of a non-commercial relationship of trust and confidence, and one person agrees to stand as surety for the other's debts. So in those circumstances, the lender is fixed with notice, and unless they protect their position, and there is then a finding of undue influence, the mortgage can be set aside. So what are the steps? They are set out in detail in Ettridge, but essentially the bank must advise the person at risk of undue influence to obtain their own independent legal advice. The bank must then provide that person, the solicitor giving the legal advice, all the relevant information about the mortgage and the debts it's securing, and then obtain written confirmation from the solicitor that has given the mortgagor sufficient advice. That the bank doesn't have to check that the solicitor actually gave, doesn't have to sit in on the meeting to check that the proper advice was given. It can just rely on the written confirmation. And then plainly, if the written confirmation shouldn't have been given because the solicitor hasn't given that advice, then the borrower will have recourse against that solicitor. But for the bank's purposes, they just need the written confirmation. So when looking at a defence of undue influence, that's what you really need to be establishing. If there isn't this written confirmation from the bank, from the solicitor to the bank, then it's definitely in play if you can establish the other requirements of the defence. Now I'm going to look at lack of capacity, because this is certainly a defence that can apply to a vulnerable borrower, where a borrower has probably been taken advantage of, because if they lack capacity, they shouldn't have been taking mortgage out in the first place. But it's important to know the limits of this defence, because whilst on the one hand it may seem like an absolutely cracking defence if the borrower lack capacity and the mortgage has been granted, it doesn't necessarily get you home. And the defence will apply if the lender is or ought to have been, and that has been said by the Supreme Court probably to mean apparent or suspected. So that's when the person ought to be aware of someone lacks capacity. If their lack of capacity is apparent or suspected, then if that arises, then the mortgage is voidable. So if the mortgagee grants a mortgage to someone without capacity and they genuinely have no awareness of the fact that the borrower lacks capacity, then the mortgage is binding and it's not even voidable. So you have to show that the lender either knows or ought to have known that the mortgagor lacked capacity, and that's obviously going to require medical evidence at the date that the mortgage was granted. Well, obviously you won't necessarily have mortgage medical evidence from the date that the mortgage was granted, but the doctor providing the evidence will have to go back and say at the date the mortgage was granted, not only did the borrower lack capacity, but it would have been apparent to anyone who met the borrower. It's then for the borrower to elect that the mortgage is void, and until that's done, the mortgage subsists. And if you have someone that lacks capacity, then obviously it's going to have to be the official solicitor having been appointed, or a deputy perhaps having been appointed, which does that, because a person lacking capacity is not going to be able to elect to treat the mortgage as being void. And one of the problems with this defence as well is that even if you can establish that the mortgage is void, it will still be a requirement for the borrower to give counter restitution, i.e. they'll have to pay the sums that were advanced back, albeit you ought to be able to recover any costs and interest that were paid, because if the mortgage is discharged, then they won't be payable under the mortgage. But there is a requirement to give counter restitution, and so that may be difficult to honour, especially if someone has taken advantage of the person who lacked capacity and has spent the money that's been advanced. If it was just spent on the property, then the likely recourse is to sell the property. May also be possible to bring a counterclaim for breach of MCOB if a lender is granting mortgages to a person who lacks capacity. That is almost certainly going to be a breach of MCOB, and if that results in other losses to them, then there may be a counterclaim as well, and if not, it will certainly be possible to complain to the Financial Ombudsman. Equality Act, as I sort of alluded to earlier, I think that's going to be difficult to apply as a sort of a knockout blow to a claim for possession, because it's hard to see, in my view anyway, how it would be disproportionate for the lender to recover possession in order to enforce security where there's no other way of recovering the sum loaned. I just cannot see a court saying that it's disproportionate for a lender to seek to recover by taking possession the property in order that it can be sold to recover the security. Therefore, in my view, you're really only going to be able to use it to buy more time where the powers under the Consumer Credit Act do not apply. Say it's not a regulated mortgage contract, it's an exempt agreement, and where the jurisdictional threshold in Section 36 can't be met because the court can't be satisfied that the arrears can be repaid within a reasonable period. It's likely that that's in those circumstances that the Equality Act is going to add value, because for the most part, say that the court's powers under the Consumer Credit Act are going to be sufficient to buy time, which is probably likely to be the proportionate response where a disabled borrower has got into arrears. Now, we've reached the end. There's only one more slide after this, and certainly I've been getting tired, so I hate to think how you're all doing there. And it's been a lot to process, but we have finally reached the end, and can deal with this slide very quickly. In short, it's always important to have in mind that there is a real need for speed after the possession order. As I said before, once the property has been sold, the equity of redemption is lost, and that's it. Game over. There's no coming back from that. Before sale, but after eviction, there are limited options available to a borrower. First is pay the outstanding balance, claim for equity of redemption to satisfy the equity of redemption. As I've said earlier, that's unlikely to apply. So what you're essentially left with is to set aside the possession order and or warrant. There's case law which says that the court's powers under Section 36 end on eviction, so you can't use Section 36 in order to support the setting aside of a possession order or a warrant post eviction, and it's unclear, there's no case law, whether the powers under the Consumer Credit could be made after eviction. So you're essentially going to have to resort to the classic Section 39, CPR Part 39(3), to show that you would have had a reasonable prospect of success, and or show that the warrant was obtained by oppression, which you're all probably very familiar with. The other thing I would just flag at this stage is if the sale is imminent, it's vitally important not just to apply to set aside the order or the warrant, but also to get an injunction to prevent sale. Because say, for example, the contracts were due to be exchanged at the end of the week, setting aside the possession order or the warrant is going to have absolutely no benefit to you whatsoever. You may be able to get your client in for a couple of days, but if it doesn't stop the sale from happening, then the equity of redemption is going to be lost. So if you fear that the sale is imminent, you need to not just be focusing on setting aside the possession order or the warrant, but also obtaining an injunction. Now, if you're before eviction, so there's a possession order that's been made but hasn't been enforced, then the court still has the powers to suspend the warrant and for a time order to be made. Even there's no authority on that, but that's absolutely clear that those powers still arise. And also where you don't have a regulated mortgage contract or regulated agreement, then the powers under section 36 still apply, and they apply up until the possession order is executed. So if a possession order has been made but not executed, there's still time, and you can still utilise any of the defences to suspend warrants. If you think that your client has a good defence, but they didn't attend the hearing, then you might want to also apply to set aside the possession order so that you can plead a proper defence. But once the eviction has happened, then the remedies available start to narrow considerably. So that brings us to the end of the webinar. I hope some of it is filtered in. Certainly, I hope that it's giving you an overview of the types of defences that are available and where to look in more detail when you have the time. And if this is going to be an area of law that you practice in regularly, you really are going to have to get the text that I referred to earlier and familiarise yourself with the types of defences that are available and when, because there's just so much here. And whilst hopefully this is signposted you to where to look, today can really only be no more than an overview. If you do have any questions, I have deliberately put my email at the end of this webinar, and even if it's not live and it's recorded, subject to the questions being asked, if they are about the law, I'm more than happy to respond. It depends how many I get, I suppose, and how busy I am. What I obviously can't do is advise on individual cases, but if there's anything from this talk which you thought was unclear or requires further explanation, I'd be more than happy to field questions via email. But again, apologies in advance if I don't respond timelessly to all, because I may be busy and having other things to do. But I hope there's a bit of assistance. Thank you.
Hello, it's me again, back again for Postscript, I'm afraid, because when editing the webinar, I noticed that the last bullet on slide 11, titled pre-2016 regulated mortgage contracts, contained an error. The slide had said that the financial limit of £25,000 was dropped in April 2014. It was actually April 2008. I'm not sure why that error made its way into the slides, but I apologise. And the slides accompanying the webinar have been amended to reflect that change. Having watched it back, I also thought, especially as I'm giving this postscript now, that I wanted to just clarify something I said about mortgages granted before October 2004 not generally being regulated mortgage contracts. And while it is very unlikely, I just wanted to make it absolutely clear that it is actually possible for a first or second charge of a dwelling to be a regulated mortgage contract, even if it was granted before October 2004. And I don't think I made that clear enough when giving the webinar originally. It is, though, very unlikely, and that's because to qualify, the sum loan must have been less than £25,000 for mortgages granted after the 1st of May 1998, or £15,000 for mortgages granted between 1985 and 1998. And hence, while a number of mortgages will have been granted for those sums in that time, not very many will have been, and those that still exist are likely to be small in number. But there are probably in certain parts of the country likely to be mortgages that are regulated mortgage contracts, even if they were granted before October 2004.